Welcome to meeting number 26 of the House of Commons Standing Committee on Justice and Human Rights. The committee is meeting to discuss the nomination of the Honourable Michelle O'Bonsawin to the Supreme Court of Canada. Today's meeting is taking place in a hybrid format pursuant to House Order of June 23, 2022. Members are attending in person in the room and remotely using Zoom applications. The proceedings will be made available via the House of Commons website. For those on Zoom, you have the choice of, at the bottom of your screen, of either floor, English, or French. And I believe we have Madame Laurie Edouard, who might be speaking in Inuktitut, and there'll be translation services during her speaking time as well. For those in the room, you can use the earpiece and select the desired channel. I'd like to welcome our witnesses, the Honourable David Lametti, Minister of Justice and Attorney General of Canada, and also the Honourable Wade McLaughlin, Chairperson of the Independent Advisory Board of the Supreme Court of Canada Judicial Appointment. So, gentlemen, the floor is yours.
Thank you very much, Mr. Chair. Honourable colleagues, to begin, I would like to acknowledge that I'm speaking to you today from the traditional territory of the Algonquin Anishinaabe people. I would also like to thank the Chair and members of this committee, here and virtually, for convening this special session in late August. I'd also like to thank the Honourable Wade McLaughlin, Chair of the Independent Advisory Board for the Supreme Court of Canada Judicial Appointments, for joining us today. It's a great honour for me to speak to you in support of the nomination of the Honourable Justice Michelle O'Bonsawin, a nominee of the Supreme Court of Canada. I'm confident she will serve Canadians exceptionally, upholding the Court's highest ideals and guiding the evolution of Canada's laws. I offer my heartfelt congratulations to Justice O'Bonsawin, and I look forward to her appearance before parliamentarians this afternoon.
It's now the fifth time that our government is following the process that was put in place by the Prime Minister in 2016 to name judges to the Supreme Court of Canada. And for me, as Minister of Justice, I am fulfilling my role. While I reflect on this process, 2 points come to mind. First of all, it produces nominations of exceptional judges who bring to the court not just uncontested judicial excellence, but also a rich humanity and a deep understanding of the diversity of Canada. The appointment of jurists was largely saluted by all sides and the judicial community in general. Secondly, and perhaps more important, is the confidence that Canadians have in the process itself. As the members of this committee know very well, trust and confidence of the public in our court system is precious, and we have to guard it constantly. It is a vigilance that is very necessary when it's a matter of selecting justices for the Supreme Court of a country. The way in which this is done can affect trust and confidence for better or for worse.
Be proud of a process that incorporates values and elements that the public can trust. A process that is free of partisanship, relying instead on rigorous assessment by an independent board. Adhering to this process, vacancy after vacancy gives Canadians confidence that the government is clearly committed to the values the process enshrines. This provides stability, which I believe strengthens the court and the public's confidence in it. In global times of conflict, polarization, and the erosion of trust in democratic values, it is more important than ever to commit to processes such as this one that are fundamental to strengthening our democratic principles. Processes that are understood and respected by the broad Canadian public allow us to peacefully thrive in our diverse society. In light of this, I want to thank you, the members of this committee, for your contributions and support of the process. Before describing the process in a bit more detail, I would like to take a moment to express my sincere gratitude on behalf of all Canadians to Justice Michael Moldaver, who will be retiring from the Supreme Court next Thursday. His contributions to the criminal law are unparalleled, and his wisdom and collegiality have brightened the Supreme Court for almost 11 years. Justice Moldaver has led a career marked by a deep commitment to justice and fairness, and to a justice system that the public can understand and trust. His contributions to the Supreme Court, to our jurisprudence, to our justice system have been monumental. So it is with deep gratitude that I thank Justice Moldaver for his service, wish him much joy in his retirement, and wish him the best and success, all the best and success in all his future endeavors. Pour revenir au processus.
To come back to the selection process, I would point out that the candidates must not only demonstrate judicial excellence and professional excellence, but they also have to show the way in which their life experience has shaped their understanding of Canadian society in all its diversity. The process is based on a merit system. It is transparent, and it is made up of a consultative committee that is made up itself of highly qualified persons. I would like to introduce the Honourable Wade McLaughlin, who appears to be with me today, chair of that advisory committee. And I'm also very grateful to the persons who worked with Mr. McLaughlin on the committee. These members are designated not only by the government, but they are also put forward by organizations that seek to preserve the rule of law and to preserve the law in Canada, the Association of the Canadian Bar, rather, the Federation of the Council of the Federation of Law Societies of Canada, and others.
The Board was amended to expand the Independent Advisory Board to include a member nominated by the Indigenous Bar Association. This change flows from my mandate letter commitment to work with stakeholders to encourage Indigenous persons to join the bench. I am grateful to the Indigenous Bar Association for its support in this process. The composition of the Independent Advisory Board ensures that the judicial selection process mirrors a critical aspiration for the Supreme Court itself, that it truly reflect our society and to be a place in which Canadians can see themselves and their life experiences represented. Le Premier ministre Trudeau a lancé.
Prime Minister Trudeau launched this process on April the 4th, 2022, and the advisory committee was given the mandate to recommend between 3 and 5 Canadians who would be highly qualified, bilingual, effectively bilingual, and representing diversity in Canada. And following the practice of long date, the candidates were selected from Ontario, qualified candidates because of the opening. And that was done on the basis of merit. The review involved the Chief Justice of Canada, interested parties, and also meetings with other candidates. The meetings were carried out in a confidential way in camera. And at the end of the consultations and the review, the Independent Advisory Board gave the Prime Minister a report on the selected candidates. I then looked at and consulted this limited list. I consulted the Chief Justices, including the Chief Justice of Canada, the Attorney General of Canada, spokespersons for justice in other areas in the House, and also senators, as well as emeritus members of the bar. But it is the Prime Minister who makes the final choice.
Wade McLaughlin to speak to the process from his perspective, and then I will return to say a few words about the nominee. Wade.
Absolutely, your pleasure.
Monsieur le Président.
Chair, members of the committee, Mr. Minister, good morning, everyone. It was a very profound honor for me to sit as chair of the Independent Advisory Board for selection of Supreme Court justices' appointments.
Of an impressive group and dedicated group of Canadians who served with me as members of the Independent Advisory Board for nominations to the Supreme Court of Canada. The other 7 members of the Independent Advisory Board are l'Honorable Louise Charon, ancien juge de la Cour.
Honorable Louise Charon, former Justice of the Supreme Court of Justice, who was designated by the Canadian Judicial Council, Jacqueline Boré, who was put forward.
Board work, Ms. Horvat was elected Treasurer of the Law Society of Ontario. A reminder that board members had other things on their plates as well as this important work. Dr. Richard Jockelson, Dean of the Faculty of Law at the University of Manitoba, nominated by the Council of Canadian Law Deans. David Nwigabo, nominated by the Indigenous Bar Association. I might add that during the course of our work, Mr. Nwigabo was awarded an honorary Doctor of Laws by the Law Society of Ontario during its June 2022 call to the bar ceremony. Paulette Senior, CEO of the Canadian Women's Foundation, nominated by the Minister of Justice. Conrad Siwi, ancien grand chef de la nation Huron.
Former Grand Chief of the Huron-Wendat Nation, designated by Minister of Justice.
Of the Ontario Bar Association, nominated by the Canadian Bar Association. The members of the Independent Advisory Board all brought to our work a background of professional accomplishment and a vast array of experience. What's more, they brought a profound commitment to the rule of law, the institutional significance of the Supreme Court of Canada, and the best interests of our country and all Canadians. We worked diligently with considerable commitment and priority of time and working time studying and deliberating together. I might add that we enjoyed working together. Le Comité consultatif a pour mandat.
The mandate of the Independent Advisory Board is to identify candidates for appointment to the Supreme Court of Canada. They have to be of the highest caliber. They have to be functionally bilingual, and they have to represent Canadian diversity. The process that has just finished was open to candidates from the province of Ontario. The ultimate task of the IAB was to present to the Prime Minister for his consideration a report containing a short list of 3 to 5 persons who are highly qualified.
Of some very helpful guidance and wisdom. Right Honourable Kim Campbell, who served as chair of the advisory board for the previous 4 Supreme Court nominations, was most helpful and encouraging from the earliest stages of the process, offering wisdom and insights based on her experience. The Right Honourable Richard Wagner, Chief Justice of Canada, met with our advisory board early in the process to discuss the institutional needs of the court and the role and demands of a Supreme Court justice. Throughout our work, the advisory board was supported by the Commissioner of Federal Judicial Affairs and his accomplished and dedicated staff. When it comes to filling a position on the Supreme Court of Canada, the first task is to get the word out. Now, on the face of things, that seems rather obvious, and some might wonder why it would be necessary. Justice Michael Moldaver announced in late February that he would retire September 1st after 11 years on the Supreme Court of Canada and a total of 32 years as a judge. Most interested observers would have known that Justice Moldaver will turn 75 in December. The point about getting the word out is not so much to give notice, but to set in motion networks of encouragement. Lawyers and jurists who are highly qualified in a way that makes them contenders for appointment to the Supreme Court of Canada are not in the habit of applying for a job. They may need an encouraging nudge from colleagues. They will need to talk it over at home, to weigh family considerations, including what it means to move or relocate to Ottawa. They are required to complete an elaborate application, as you will have seen from studying the file of Madame O'Bonsawin, that delves deeply into their professional track record and experience, as well as personal skills and qualities. They may be members of traditionally underrepresented groups. Dans les jours qui ont suivi ma nomination,
in the days following my appointment to the chairmanship of the board, and further to the announcement by the Prime Minister of the process to select the judge, I wrote many letters to quite a variety of lawyers' associations and interest groups in the legal field. I also wrote to the Chief Justice of the Appellate Court of Ontario, the Superior Court of Justice, the Federal Appellate Court, the Federal Court, and the Court of Justice of Ontario. And I followed up by phone with the Chief Justices. Those calls and letters were intended to encourage, but not to seek, specific candidates.
Of applications was May 13th. The other 7 members of the Independent Advisory Board were confirmed about the same time. We had our first in-person meetings in Ottawa on May 19th and 20th. Our report to the Prime Minister was completed on June 22nd. This is an intensive process, calling for much discernment and humanity, in addition to dedicated preparation and time commitment. Of course, this is the case for the candidates who put their names forward, as well as for Independent Advisory Board members. There were 12 applications. The Independent Advisory Board opted to interview 6 highly qualified individuals. The interviews were extensive, giving candidates upwards of an hour to respond to questions about their experience, views, and commitment to serving on the Supreme Court of Canada. The Independent Advisory Board was especially interested to explore candidates' approach to collegiality, the workload of the court, and issues of integrity, diversity, and judgment. Our checklist of criteria for assessment included superior knowledge of the law, superior analytical skills, ability to solve complex legal problems, ability to work under significant time pressures requiring diligent review of voluminous materials in any areas of the law, and commitment to public service. The personal qualities assessed include irreproachable personal and professional integrity, respect and consideration for others, ability to appreciate a diversity of views, perspectives, and life experiences, including of groups historically disadvantaged in Canadian society, moral courage, discretion, and open-mindedness. All candidates interviewed were functionally bilingual. The interviews were conducted in both languages, both official languages. Immediately following the interview, each candidate participated in an assessment conducted by the Office of the Commissioner of Federal Judicial Affairs to ascertain the candidate's understanding of written and oral arguments, as well as to determine the candidate's ability to speak in both official languages. A report, including candidates' assessment scores, was provided to the Independent Advisory Board. The Independent Advisory Board pursued references for each candidate interviewed, as well as discussions with Chief Justices. The interviews were conducted by IAB members who spoke directly to referees following a consistent format. The ultimate task of the Advisory Board is to draft and finalize a consolidated report. From the beginning of this process to the end, there has been total respect for the need for confidentiality. A further commitment of the Independent Advisory Board has been to treat every candidate who submitted an application with fairness, dignity, and good grace. Le processus implique
The process involves considerable study, discernment, and consideration of many details in the space of approximately 6 weeks or even less. And the devotion that was total on the part of the members of the board meant that they were able to do that. It made a difficult task easier because of the devotion of the AIB members and the support they received. The work was done with diligence, collaboration, judgment, and that helped the process. That being said, though, I think an additional week or 2 for the time frame would be beneficial for future appointments to the Supreme Court.
Before this committee, the Right Honourable Kim Campbell spoke about the desirability of having what she referred to as a broader conversation among people in the profession and the community about what is required to be a Supreme Court justice, so that there's a greater knowledge of what is actually entailed. In her 2019 appearance, Madame Campbell spoke about this in the context of building an environment which might encourage even more people to apply. She said, "I think, particularly for women, if they have families and are likely to have spouses or also have careers, this might be something that could overcome some reservations." She said, "If this were an ongoing conversation, as opposed to something that we scramble to do just in the face of an imminent departure from the court and the need to recruit a new candidate, I think it might be something that could broaden the scope of candidates." I concur with these comments and note that both Chief Justice Wagner and former Chief Justice McLaughlin have taken significant steps to enhance the profile of the Supreme Court of Canada. In September of this year, the Supreme Court will sit in Quebec City, following the model of its first out of Ottawa hearings in Winnipeg in September 2019. All members of the court participate generously through speaking engagements and other public activities, such as the feature television interview given in June by Justice Jamal on the one-year anniversary of his appointment to the court. Still, there is what I call an episodic quality to the appointment of a Supreme Court justice. Given the ages and stages of the current justices, it could be a number of years before the next vacancy. That in itself is not a bad thing. There has been considerable change in the membership of the Supreme Court over the past decade. The coming period could be a window of opportunity to enhance these networks of encouragement that I spoke about earlier in my remarks, so that lawyers and judges have more time to consider what might be involved in being a candidate for a Supreme Court appointment when the opportunity arises. The transparency and independence of this nomination process can only add to that environment of encouragement. I will conclude with two remarks. First, this process has resulted in the nomination of Justice Michelle O'Bonsawin, a highly qualified jurist who brings many gifts and talents to the Supreme Court of Canada, including as the first Indigenous person to serve as a member of the court. This in itself is convincing proof that we are making progress in building an environment of encouragement and inclusion with impact extending well beyond the work of the Supreme Court of Canada. My final remark is to say that it has been a truly uplifting experience to serve as chair of the Independent Advisory Board. It has been an opportunity of a lifetime to work with the 7 other members of the Advisory Board and our supporting team. We would all say that we treasure the collaboration, diligence, and humanity that we have shared. It has been uplifting to get to know all of the candidates who came forward for this position. We are extremely fortunate in this country to have a widely shared respect for the rule of law and for the Supreme Court of Canada as an institution. We are fortunate to have people of exceptional caliber who contribute in so many ways and in so many capacities to ensuring that this is the case and continues to be so, and ultimately to serve Canadians. The opportunity to appear before this committee today reinforces those values. And as I close, I'm going to refer to a note I got, one of the very first when I took on this task from a former member of this committee, the Honourable Murray Rankin, who now serves in the government of British Columbia. Murray, I've known for many years, writes, "Dear Wade, I was delighted to learn of your new role in SCC judges selection. You're perfect for this vital role." That's not why I'm reading it. He writes, "I was the NDP Justice Critic for 3 appointments and must say how proud I was as a Canadian of this process." And I think that that's a sentiment, Mr. Chair and committee members, on which I close my opening comments this morning and look forward to an exchange through questions. Merci.
Thank you, Mr.
Thank you, Wade. In the brief time I have, I cannot possibly paint a full picture of the professional and personal experiences and accomplishments of Justice Michelle O'Bonsawin. I instead offer a brief sketch of her background. La juge O'Bonsawin a grandi.
Judge O'Bonsawin grew up in Hammer, a small francophone village near Sudbury, Ontario. She was a francophone in Northern Ontario, and she became aware of the devotion that many people had to give a voice to people who could not speak for themselves. That inspired her to become a lawyer. She obtained a BA from Laurentian University, a law degree from the University of Ottawa, and was admitted to the Ontario Bar. She began her legal career within the legal services of the RCMP and acted as a lawyer for Canada Post, where she was specialized in labor law, human rights, and privacy law. She became the general counsel for the health group at the Royal Ottawa, and she acquired a very deep understanding of mental health and the principles that are set out in the mental health system, but in the legal context. And she has worked at legal tribunals as well. During all these positions, she got her MA in law from Osgoode Hall, specializing in mental health. In 2017, she was appointed to the Superior Court of Justice of Ontario. And 2021, she obtained a doctorate in law from the University of Ottawa, specializing in Indigenous issues and mental health.
Background provides significant grounding in important areas of criminal law, namely mental health law, as well as the implementation of Gladue principles. At all stages of her career, Justice O'Bonsawin has volunteered with numerous organizations devoted to improving our justice system and our society more broadly. She has been actively involved as an educator, providing continuing education courses to members of the judiciary, as well as teaching at the University of Ottawa. Throughout her career, she has remained rooted in her Abenaki First Nation of Odanak. This includes participating in ceremony, being supported by elders, and taking courses in the Abenaki language. I could go on, but I believe that even this brief sketch speaks to the professional and legal excellence of this fluently bilingual and accomplished jurist. Let there be no doubt that there are qualified Indigenous candidates who speak both official languages. Let me end by noting one aspect of Justice O'Bonsawin that stood out for me. Her commitment to put her talents, knowledge, and experience to the service of others. She is dedicated to continually sharpening her skills and broadening her knowledge so that she can be of better service to others in their vast diversity of needs and backgrounds. I need only to point to the fact that despite her being a member of the judiciary, she persisted in completing her research and defending her thesis for her doctoral degree while continuing to sit as a full-time judge. As someone who has completed a PhD, I must admit I find it hard to imagine doing so while having a full-time job as demanding as that of a Superior Court judge. Justice O'Bonsawin has shown extraordinary commitment in her legal career. As the first Indigenous Justice of the Supreme Court of Canada, Justice O'Bonsawin will bring invaluable perspective and deep wisdom to the court. This is an historic moment, not only for the Indigenous peoples of Canada, but for all Canadians. The court's decisions are enriched and strengthened when justices bring diverse perspectives. The court's legitimacy is enhanced when Canadians see themselves represented on the court. Thank you, Mr. Chair. I look forward to answering your questions and to those of committee members.
Thank you, Mr. Lametti and Mr. McLaughlin. I now will go to our first round of questions. We'll have them at 6 minutes to begin. We'll begin with Mr. Moore for 6 minutes.
Well, thank you, Mr. Chair. It's good to see you again, and Minister, as well as Wade McLaughlin. Good to see both of you. I hope you're doing well, and thank you for your contributions to this process that has resulted in the nomination of Justice O'Bonsawin. And I do want to echo, Minister, your remarks around the retirement of Justice Moldaver and wish him well in his retirement. When we speak about the process, and Wade McLaughlin mentioned some of the various individuals involved, some of them are former judges, former premiers, former prime ministers, individuals that have honorable or right honorable in front of their name, and that's important to have the views of individuals with deep experience in the process. But I think it's also important, and I was listening to some of the remarks by Justice Obonsawin when she spoke of access to justice and Canadians feeling a part of our system. I think it's important too that everyday Canadians have the ability to give input through this process, and one of the ways they do that is through us, members of the House of Commons. It's our job to represent the views of everyday Canadians, our constituents. And later today, we were invited to what was called an informal, moderated Q&A session, not an actual committee of the House of Commons or of the Senate, but a moderated Q&A session by someone who is not moderated by someone who is not a parliamentarian. I want to ask, Minister, your thoughts. Do you feel that I have faith like our chair of of the Justice Committee could have easily conducted this meeting and have it a more formalized parliamentary committee rather than an informal chat, while still respecting the individual, the nomination, and the process. I have every bit of faith that he and our members of the committee could have done that and maintain that stronger link, I feel, back to our constituents by doing our role as members of parliament, not as an informal Q&A session. I want to get your thoughts on that. That's something that struck me when the invitation came out.
Thanks very much, Mr. Moore. Always good to see you again, if only at a distance. And I hope your summer has gone well. Look, you've just asked a very important question in terms of the process. Let me say first of all that I think this is a good process that balances the ability of parliamentarians, and I share the view that parliamentarians have to have a role in this. That's why we're here today. That's why you and others were consulted in my phase of consulting on the short list of candidates. And you are here today asking questions. Our colleagues are here today asking questions as well. So I share that. It was a process that was long sought after. Prior to 2016, there wasn't really a formal process for the selection of judges. A number of people weighed in. My predecessor, my former professor, Erwin Kotler, weighed in with suggestions, and other experts, Professor Martin Friedland at the University of Toronto had weighed in as well with suggestions on how to create a process that allowed for independent evaluation of a dossier as well as parliamentary input, but did not turn into something that happens occasionally south of the border where it becomes hyper-political and hyper-partisan in terms of the nomination process for Supreme Court judges. I think this represents a good balance. I think there is a strong role, as you are playing right now, for parliamentarians to participate in this role, in this process. Obviously, I'm always willing to entertain suggestions on how to make it better.
Thank you, Minister. And I thought that is what you would say, and I don't share the concern around hyperpartisanship. I have every bit of faith, having worked with members around our Justice Committee, that they would be able to engage in this process in a parliamentary committee, one of which I participated in with the appointment of Justice Rothstein, an ad hoc parliamentary committee, would be able to conduct themselves in a way, as I said, that respects the gravity of the process. We are all well aware of the impact of decisions that come from our Supreme Court, the weight of the types of decisions that are being contemplated, as well as the very real impact they have in our day-to-day lives. I heard from Justice Obonsawin a commentary around access to justice. And I don't want to miss the opportunity, Minister. This is an important appointment. A vacancy was created, and your government is acting to fill it as it should. And I would be remiss if I did not take this opportunity while you're here at our Justice Committee just to remind you, as I've done over the months, of the vacancy in the Ombudsman for Victims of
Mr.
Crime,
Moore,
and ask that every effort be made to have that position filled as quickly as possible.
unfortunately, Mr. Moore, we're out of time for that round, and hopefully I'll ask Mr. Lametti if he can answer that in the subsequent answer.
That is in process. As I've said, that departure was unexpected, and it hopefully will have something to announce relatively shortly.
Thank you, Mr. Lametti. Thank you, Mr. Moore. I'll next go to Mr. Batista. Thank you and welcome to our committee today.
Thank you. I'm deeply honored to be here today on this very exciting and historic day. In my language, we would say Galuk Nagwek in the Mi'kmaq language, and saying this is a great day. And it's a great day for many reasons. As someone who is a member of the Indigenous Bar Association for more than 20 years, as a student, and then coming back as an Indigenous parliamentarian, I often heard the advocacy and the dream that someday we would see an Indigenous nominee to the Supreme Court of Canada. And in fact, this is an important thing that the Indigenous Bar Association and the Canadian Bar Association have called for since 2005, when they said this was integral for Canada and for us to advance Indigenous laws through these appointments. Even more so with the calls, the TRC calls to action, almost a quarter of the calls to action call for justice and equity for Indigenous people within the legal system. And Minister Lametti, you spoke to the importance of having a justice system that reflects the Canadian public, and how having Indigenous laws enriches our Canadian justice system. I'm wondering if you could speak to the gravity and the historic moment that we're at today. For so many years, Indigenous people have looked to Canadian laws, despite having their own Indigenous laws, and saying, you know, we will trust within these systems that have been created. What do you think it means for the justice system today to have this historic day finally upon us?
Thank you for that question. I recognize the historical moment that this is. I recognize the importance that this is. I recognize your passion and your emotion in answering the question, and so I understand how important this is, not just to you, but to Indigenous peoples across Canada, and hopefully non-Indigenous Canadians as well. It is extremely important that Indigenous peoples be able to see themselves in what are, quite frankly, colonial institutions. And see their participation as a way of making those institutions better, and see this as a way of making Canadian law better, the substance of legal decisions, to improving the substance of those legal decisions. So this is incredibly important, to have that diversity reflected within the deliberations of those 9 justices of the Supreme Court. But it's also critically important for everyone else throughout the system to know that this is possible. And it helps. We have made progress on diversity in appointments. There are, I have in recent months elevated 2 people to courts of appeal of Indigenous backgrounds, Len Marchand, Justice Len Marchand, British Columbia, Justice Jonathan George in Ontario. It is critically important for other Indigenous jurists and Indigenous peoples to see that they will be treated seriously in applying to whatever level of bench that they apply, and that they will be treated seriously in the practice. And it also gives a boost to Indigenous laws themselves and the revitalization of Indigenous legal systems, because it adds to the legitimacy of those revitalization projects, which are critically important as we move forward to making Canada a truly pluralistic legal system, or recognizing pluralistic legal systems within Canada and recognizing legal systems, normative systems that have been here since time immemorial. And so it's important on so many levels. I'm proud to be here.
Chair.
You have
Did you want to?
a minute and a half.
If I may, I'd like to add to what the minister said, and to totally agree with it, and to appreciate the question from Mr. Batista, and to expand on it, to say that in addition to the perspective and experience and commitment that Madame O'Bonsawin, that Justice O'Bonsawin will bring to the court, by bringing that element of diversity, it will add to the deliberation of the court on all of the matters that it's dealing with, and the appreciation that Canadians have for the capabilities and the reputation and integrity of the court itself. And this is an important piece of our path of reconciliation, and it's an important element of how we continue to build a country of diversity, and where we're always learning, where we're always growing, and where the Supreme Court of Canada, as a court of general jurisdiction, will show leadership, as it has, that Canadians can continue to benefit from having a court that is fully representative of the country as we continue to learn and grow and reconcile, and it is indeed historic. Thank you.
Just like to thank you both for those comments.
Thank you, Mr. Batiste, and thank you. Now we'll go on to Monsieur Fortin.
Merci, Monsieur le Président.
Thank you very much, Chair, Minister, and also to the Chair of the Advisory Board. I must begin by speaking to the diversity of the Supreme Court. This is a matter that we have always been sensitive to in the Bloc Québécois, and these appointments are a part of the way in which we all see diversity. Clearly, even though I haven't had the pleasure of meeting Justice O'Bonsawin in person yet, I am very reassured about her competence, and I'm looking forward to this afternoon. This being said, Minister, you are aware of our sensitivity in the Bloc Québécois with respect to impartiality of appointments. So before getting into other subjects, I'd like you to confirm, yes or no, whether the list was consulted or not before the appointment of Justice O'Bonsawin. No. Not during the process. No, I looked at the list yesterday, just to be honest, because I knew you were going to ask me the question, what your list was. Thank you. Thank you, Minister. I have a question for Mr. McLaughlin. I said at the outset that we are very aware of the importance of diversity, but I wonder about the way in which you proceeded, because we understand that everyone wants to have people appointed who come from diversity, from a variety of backgrounds, and it's our pleasure today to welcome Justice O'Bonsawin today. But how do you evaluate the competency of the candidates? Do you have some sort of ultimate criteria that you keep in mind? Do you proceed, say, with a list of white men, a list of white women, a list of black men, a list of Indigenous persons. How do you do that, all the while assessing the best candidates' characteristics? Well, basically, diversity, that issue is resolved when the candidate comes forward. The advisory board is a group that has been seized with candidates that have stepped forward, and therefore we evaluate their professional competency, their character, their way of interacting, and so we look at the application that was submitted by Justice O'Bonsawin to the committee, and that other candidates submitted to the committee. We look at all of these, and the application, of course, is a very broad one, a detailed one that covers a variety of subjects. But finally, for us, it's a question of quality. The quality and the competency of and the character of the candidate that is being assessed by our committee. So if I understand correctly, you recommend between 3 and 5 nominees to the Prime Minister. So of those candidates that postulated their position, the 5 best, would I be correct in thinking that the 5 best candidates, say, who didn't reflect diversity, would still be recommended to the Prime Minister? Or would you perhaps attach a certain advantage to a candidate who comes from a background of diversity? The committee has a very detailed report. A report that it gives the Prime Minister between 3 and 5 names of extremely qualified persons, highly qualified persons. And we also include our reasoning for the qualifications that are set out. We give that to the Prime Minister and to give him the time to study it and to consult the names of that are submitted in the report. Well, I thank you for saying that. But in the case, say, where you had say 20 very highly qualified persons, how would you proceed? Would you select? Well, my question really is this. Is the issue of selecting someone in light of a diverse background not something that should be determined by the Prime Minister? Do you not in any way take into account the competency, excluding the diverse background? No, the work of the committee is to assess the competency of the candidates and to establish a list that will leave the Prime Minister the choice of making the appointment. As far as diversity, well, we as a committee have candidates who have stepped forward and have submitted their application. After that, there is a very serious task that requires detailed study, and that, of course, is done in a collaborative way by the committee to reach a consensus on the individuals who are qualified to be included in the report that is given to the Prime Minister. I can tell you that of the 12 candidates that we had. This time I was very, very impressed, highly impressed by the professional quality, by their character, by their convictions, and by the work that they have done to complete this detailed application. Thank you very much.
Welcome, Madam Idlouat, and over to you for 6 minutes.
Koyarigo mabase unikatia sagase amaru okago madlunga kauye mayuin naugatat Canada tungang man nunakakak si mayo nunanginin nunakakak si mayok tigut
Point of order. Sorry, Lori, but we're not getting the translation. I see that she's speaking it, and so it's probably a technical problem because I hear her translating, but we don't get it in the in the earpiece. So.
I'm just going to have the clerk check on that, and it may take a few seconds because I think it's being translated into English and then to French.
Should I get it closer to me? Bukadlaw yagak lungat na magsilang mga kawigatin ng napunga. Tukasinak si titaw badliang mga kawigak lota. Bukadlaw na kung naktunga. Narunak taw gumabunga.
We don't have any translation in French either. We cannot hear my colleague in French either.
Si on a la traduction cet après-midi, ça fonctionne.
If we don't have translation this afternoon, it's not going to work out, is it?
From the beginning, and we'll reset your time. Hopefully this will work.
Kadlagyakan naglunga iman nago akik seman yang mat inuk dito ukadlag tidlunga tusayiga kadluna titorak tidlunyo kadluna titorak tikangamyo wewe tito akik soktarang ni action nego teman na
No translation, Mr. Clerk?
Non.
Yes.
Sur le 3, c'est en anglais.
On 3, we have it in English, but we don't have it into French.
On our floor.
No. I'm doing Inuktitut.
But you're doing from Inuktitut to English, right?
Yes.
Yes.
Okay, got it. I can no longer hear the woman talking. I can't hear her.
Ayaw no tuniyaw niyang mat
Sorry, Mrs.
kauye mayunga.
Yeah, we cannot hear. Sorry for that.
If you wish, I will speak now so that we can look into this technical issue while I speak. While I speak, it will be translated into English, then it will be relayed into French. Is that my understanding?
I'm just going to suspend for a minute. I don't know.
Nukangalaw kan niagata. Nukangalaw pitlag tilutata na akiyak daw niyaman.
We will wait for Mr. Lametti and then we'll resume. So, Ms. Idloy.
Idlog, ukalaw na sibutit. Thank you. Shall we start again? Firstly, I am extremely happy to be here. And I thank you for allowing me to be a part of this. And I can speak to you in my own language. I am very grateful for that. I know that, and we all know that Canada is multicultural, but it's also indigenous before other arrivals. We've always had our own traditional and legal processes and systems. So we still use our legal systems today. Sadly, it is no longer recognized in the court system. Although we will try to apply traditional knowledge and legal issues within the court system, it should be recognized and promoted. I am happy that I am able to sit here and say to you, when I went to University of Ottawa, I took legal studies. I enjoyed my instructor Tracy Lindbergh, who has worked with Aboriginal students and has studied Aboriginal legal issues and systems, and I gained a lot from her. And this morning, Minister David Lametti spoke, and I enjoyed when you said that the court system have to look at all the legal systems, not only in English or in French, but should also include indigenous legal systems and processes that work. Obansawin, who is now nominated, that is very hopeful. It will help us to introduce a third legal system we should be into, indigenous. Whether she's the first person appointed or not, I look forward to the day that we will do more to include indigenous and traditional legal systems. We have many issues that we cannot run for positions. Not being able to speak French is one. Will you look into that as a barrier for us? If more indigenous lawyers need to be involved in policy in the government, we need to consider bilingualism in other ways.
Ms. Idlout, it's good that you were here today on this historic day. Let me say, first of all, that under Call to Action 50 of the Truth and Reconciliation Commission's calls to action, one of the things that I am charged with as Minister of Justice is to encourage the revitalization of Indigenous legal systems, and there are many. There are hundreds of different kinds of legal systems, and both, all of Inuit, Métis, and First Nations legal systems. And so there are a number of different projects that I am supporting to help revitalize those traditions, and they are being led by Indigenous leaders, elders. I'm going to say lawyers in quotation marks because Indigenous experts in their own normative systems, and so those projects are being led, and I'm supportive of that. And I think that in and of itself will help on the day-to-day revitalization of self-government and self-determination. But also, it will also have an impact on the common law and the civil law, and the structures that exist in the Canadian legal system, and there will be a better appreciation simply because of that. The question of bilingualism is an important one. to Canada, it's very important, and it is important on the Supreme Court that we have a bilingualism as a criterion, and I think Justice Obomsawin has proven today, and there are others in the system that I know of, that it is, as an apex court, the top court in Canada, you have a whole career to prepare for it, and so bilingualism as a criterion for that court, I firmly believe, shouldn't stand in the way of good Indigenous and non-Indigenous candidates. Other courts don't require that each and every judge be bilingual. There are unilingual Anglophones and Francophones on various courts across Canada. It is an obligation for a whole court, to be able to offer services in both French and English, but that will often mean sending a Francophone judge to Northern Ontario, or an Anglophone judge to a part of New Brunswick or Quebec, where, as the case may be. And so that requirement of institutional bilingualism isn't an impediment either. And so,
if I may just interrupt you.
Please do.
I think there was a misunderstanding
actually,
about
we're out
my
of
question.
time on this round. I'll hopefully have you on the next subsequent round.
My question wasn't interpreted properly, and he ended up giving a different kind of response. That
I'm sorry if I misunderstood.
could I?
I unfortunately won't. You'll
Could
have,
I ask
I
the
believe, another
committee if I
round
could
in a few
ask
minutes.
my question?
As chair, I can't enforce the answers, but I can enforce only the time. I apologize. We'll next go over to Mr. Brock for 5 minutes.
Thank you, Mr. Chair, and good to see you again, Justice Lametti, and welcome, Justice McLaughlin. Very, very appreciative of your attendance today and your input. A couple of areas I want to follow up on with respect to my colleague Rob Moore's questioning. And I've done a little bit of research with respect to some of the information that's available on the website for the Office of the Commissioner for Federal Judicial Affairs Canada. And I understand, Minister Lametti, that once the shortlist is finalized, you are required to consult with a number of stakeholders. Obviously, the Chief Justice of Canada that you alluded to, relevant provincial and territorial attorney generals, which you've alluded to, relevant cabinet ministers that you've alluded to, as well as opposition justice critics. What I haven't heard, and is clearly spelled out in the website, is that you're also to consult with members of both of the House of Commons Standing Committee on Justice and Human Rights, as well as the equivalent Standing Senate Committee. So my question to you, Justice Lametti, is who in particular on the Justice Committee did you consult with?
I don't have the report in front of me, Mr. Brock. Thank you for the question, but I will get that to you. We did in fact consult with members of both the House and Senate committees.
Okay, I can put you on record right now that I was not consulted. I know that our justice critic Rob Moore was, but as far as the other standing members of the committee, I don't think anyone was consulted. So please look into that and advise us accordingly. I know that there are big shoes to fill with the pending retirement of Justice Moldaver. Justice Moldaver has had a very distinguished legal career, not only as a leading expert when he was in private practice, but certainly a leading expert on the bench with the Court of Appeal and the Supreme Court with respect to his impeccable knowledge of criminal law matters. Justice Lametti and Justice McLaughlin, as you know, the Supreme Court of Canada this year alone pronounced two significant decisions that has received a number of considerable commentary, not only in the press, but across Canada, as well as discussions in the House of Commons with respect to life sentences and the intoxication, extreme intoxication defenses. What specifically, what attributes, what specific experience level would Justice Obonsawin have to replace that considerable expertise of Justice Moldaver?
Thank you, Mr. Brock, for that question. Obviously, criminal law is critically important to the docket of the Supreme Court, and an expertise in criminal law is also extremely important to the docket of that court. I recall that when I was a clerk many years ago. It was like jumping in feet first to a pool of criminal law water, and I appreciated that experience very much. Justice Obomsawin brings with her a knowledge of critically important parts of the criminal justice system, specifically mental health law, which is an important part and we understand it to be an increasingly important part of criminal justice, as well as an expertise on the application of Gladue principles, which is also extremely important to the sentencing portions of criminal justice. She also brings with her experience as a Superior Court justice, in which she has had exposure to criminal law cases. I would add, though, that it is the court's total responsibility and not simply of one judge or one justice to be an expert in criminal law. I point out that court has an accumulated expertise in criminal law, as well as Justice Kassir, who was a recent appointment, who wrote and taught in the early stages of his teaching career in criminal law matters, and I believe wrote one of the decisions to which you just referred from this past summer. So there is an accumulated expertise on the court, and Justice Obomsawin is going to add to that expertise in criminal law.
Thank you, sir. I also consulted with a number of victims groups across this country with respect to the vacancy in the ombudsman position for victims of crime. What specifically will you tell those organizations as to when this vacancy will be filled? It's been approximately 11 months since the vacancy. The vacancy with respect to the Supreme Court was filled in less than 2 or 3 months. It's now 11 months. What do you say, Justice Lametti?
Well, first of all, the office continues to function and has continued to function over these 11 months. And so it isn't a case that that victims have not been supported. It is only a case of a vacancy of the presidency. Now, I appreciate that the chair, and that is an important vacancy. I know that. As I had alluded to in a previous question, I was expecting a renewal of that position, and we were proceeding in that. And then there was a change in that position. We have proceeded diligently with that process to replace that person, and as I said, I hope that announcement will be able to be made soon. I can say that the office has remained open throughout this time, and victims have been served throughout this time, and the office has been very ably run by the number 2 person in that office. So it hasn't been a case that victims have not been served. But I agree that we have pushed as hard as we can to fill that position as quickly as possible, and that is proceeding.
Thank you, Mr. Brock, and thank you, Mr. Lametti. Now we'll go over to Madame Brière.
Merci, Monsieur le Président.
Thank you very much, Chair. Mr. Minister, thank you very much for the work that you both have done in the nomination process. We certainly have reason to be pleased with the appointment. First of all, a woman on the Supreme Court, that brings them to 4, and an Indigenous person who has been appointed to the highest court of the land, a Franco-Ontarian, and a specialized jurist in mental health. In view of the fact that that is something that I have an interest and background in myself, I know that the in-depth knowledge of Justice Obomsawin will be of great help. You mentioned that you gave some indications with respect to the needs that had to be met in terms of expertise on the bench. I'd like to know what weight you attached to judicial competency, parallel experience, and so on for the candidate. Well, yes, it's a package, really. It's individual competence of the candidate, experience, professional qualities, and I think it's important to understand that the Supreme Court of Canada is a court of general jurisdiction. So you always have to look for justices who can bring competency in a variety of areas. And you're quite right in pointing out the competency and the experience in the field of mental health that is held by Justice O'Bonsawin, particularly with respect to the Gladue principle, which is a very important aspect of that we have to consider for the country and also for the court and criminal law. In the case of Justice O'Bonsawin, she has experience in labor law, human rights law, in civil litigation, and she herself has been able to bring and will be able to bring a variety of experience to the court. So you have to consider all of that together, taken together, and I encourage everyone, all Canadians, and I'm sure you've done this already, to look at the applications that we were given in the public arena, candidates for nomination to the Supreme Court, because it is of great interest. Mr. Minister, do you want to add something? As Mr. McLaughlin has just said, I just would like to add that it is, in fact, a package. Yes, we always have requirements to consider, but you have to look at the whole candidate, and you have to look at the big picture, as we say in English, how that person is going to be able to contribute to the court's operation and to the development of good rulings from the court. We know as well that there are 3 levels in the judicial system. They are similar but different at the same time. In the current selection process, how can you assess the competencies and the requirements for a justice who would be appointed to the highest court of the land? Well, before giving away the microphone, I would say this. We're looking for quality of judgment, because the Supreme Court sits to resolve conflicts between courts of appeal on questions of law and to establish norms and standards through judgments that will be used as precedents. And for me, it's really the judgment about the wisdom of the person that's very important. For me, personally, that is very important. If I could add one thing.
On that round, thank you, Madame Briard. Next to Monsieur Fortin.
Merci, Monsieur le Président.
Thank you very much. Thank you very much, Chair. Mr. Minister, if you would allow me just to complete your response earlier, you said that you looked at the list yesterday. So who did you find? It was not the Liberal list that I looked at. It was really Elections Canada that is in the public domain of people who contributed to that. There was a small quantity in terms of sums, 2011, 2012, of donations that were made to the Liberal list on the part of candidates. That was something that was unknown to myself, to the committee, to my colleague. We did not look at that during the selection process. It was only yesterday when I saw your name on the list of the participants in this committee that I thought I had better have an answer ready. Well, that's the type of reputation, I guess, that I have. Well, Madame Obonsawin is not on the list, on the Liberal list. I did not consult the list of people who were volunteers or other. Thank you, Minister. Then I'll change subject. My colleague from the NDP asked you a question earlier. In her question, I noted that she was concerned about the fact that certain candidacies, Indigenous candidacies, can be hurt because they do not speak French. Bilingualism in Canada is based on English and French in Canada. I understand your response, but I know your reputation, and I would like to hear your opinion on this. Is it essential to speak English and French if you sit on the highest court of the land? Or are you of the opinion that French and an Indigenous language could be bilingual? Look, Judge Corey at the Supreme Court in '89, I participated in that. I participated in pleadings before the court in that case that I have outlined to you. I know that each word is selected with a great deal of attention in both French and English, whether it's in French or in English. The judge, that is to say, a justice of the Supreme Court, has to be able to speak or write in the language of his choice. No, I only have 2 minutes, Minister. Well, this is very important. It's of prime importance. I don't know if you understood my colleague's question, but French will not yield to another language. It is of great prime concern, French.
So much I'll be speaking in English and hope that my interventions can be interpreted into Inuktitut. As I was saying, Canada is founded on Indigenous lands, on First Nations, Métis, Inuit lands, of which had their own laws before colonialism. And Justice Obonsawin's appointment, I think, really opens up the opportunities for a pluralistic legal system to be established and recognized. And I'm wondering if you could respond with this question. What steps can be taken, what next steps can be taken to ensure that this is not a one-time appointment of an Indigenous judge, so that we could make sure that there's actual reconciliation with Indigenous peoples whose lands have been stolen in Canada and whose laws need to be revitalized, as you've said, Kuyanami.
Kianamik, Ms. Ilut, for the question, I apologize if I mischaracterized or misunderstood your previous question. I truly apologize. I think the idea of reconciliation through the justice system has to happen at many levels. So first of all, with respect to the current legal system, superior courts, provincial courts, territorial courts, courts of appeal, Supreme Court of Canada, we need to continue to appoint diverse people, including Indigenous peoples. And I have done this since I was named minister in 2019, but I have done a great deal of outreach to try to encourage candidates to apply, to try to help candidates understand that they have something to bring to the bench. Very important that their experiences be brought to the bench. And that, in a way, makes the interpretation of the common law and the civil law much more diverse and much more pluralistic in and of itself. And I'm proud of the diversity in our appointments. I'm proud of the fact that there are a number of very good Indigenous jurists who are now sitting on superior courts and courts of appeal. and as we say in French, la relève is strong. I think this will continue to improve, and an appointment such as today helps to inspire others and builds confidence so that they will apply, whether it's for an elevation to a court of appeal or possibly the Supreme Court, or whether it's to the Superior Court or a provincial or territorial court to begin with. So I think all that is good and important. It's hard work. It is incremental. It's hard to see the progress. Sometimes I get very frustrated, but it is, I think, moving in the right direction. And also, as I mentioned, we also have an obligation, and I have an obligation as minister, to help to revitalize Indigenous normative systems, legal systems, and they have always been there, and they have always played a role, particularly in the day-to-day. And it is important to recognize that, but also to support that. It goes along with the revitalization of Indigenous languages and the protection of Indigenous languages, because the two often go hand in hand. And so I will continue to do that and look for ways, but there I'm really following the leadership of Indigenous nations, peoples, and experts in terms of how to make that happen.
Thank you, Madame Blewett. Next, we'll go to Ms. Findlay. Thank you, Ms. Findlay, for joining us today. You have 5 minutes.
Thank you very much. Thank you very much, Mr. Chair. Can you hear me now?
Yes.
Thank you. And to Minister Lametti and to Chairperson McLaughlin. Following up on my colleague, Monsieur Faure, and other colleagues' questions, I would like to ask of you each to confirm that whether you or anyone on your behalf or part of your committee consulted not just Liberal list, but anything as to the political affiliations of the candidates you vetted.
I can confirm that I did not and nobody did on my behalf until, as I said, I anticipated the question of Mr. Fortin today.
And for the committee, absolutely not, no.
Thank you. I think a lot of us in the legal profession have a great deal of respect for Justice Moldaver, and sorry to see him go. He was both learned and congenial in the way he approached his important position. And it has been mentioned before that he was a leading specialist in criminal law. And although mental health absolutely is an aspect of criminal law, my understanding is that criminal cases constitute 55% of the cases that the Supreme Court of Canada heard in 2021. So given the importance of criminal law in the court, I'm interested, Minister Lametti, on how this gap of knowledge and skill set with Justice Moldaver's retirement was taken into consideration in appointing a nominee.
Thank you. I believe that Mr. McLaughlin will answer that directly in a moment, but it certainly was something raised by the Chief Justice in his consultation with Mr. McLaughlin and the committee. What I can say is what I said before. I understand the percentage of the docket, the court's docket that is criminal law, and I understand how important that is, and I certainly understand as Minister of Justice the precedential value of those decisions that come from the Supreme Court, and you've seen that in recent weeks and months when we were sitting. As I've said before, there is other latent expertise on the bench to begin with, other justices who have experience in criminal law as well as their accumulated experience as judges at the Superior Court, Court of Appeal, and now Supreme Court levels. And Justice Obomsawin brings that with her as a former sitting Superior Court judge, but also as an expertise, also with an expertise in dimensions of criminal law that are increasingly important. So I'm confident that she will add to the criminal law capabilities of the court, and I'm confident generally in the criminal law capabilities of the court.
And let me accept the point of the question insofar as it recognizes the contributions and very significant contributions over time of Justice Michael Moldaver at the Supreme Court of Canada, as well as in his earlier judicial appointments, which go back to 1990. Justice Moldaver has been a leader in the criminal law field and including in the professional education.
With respect, Mr. Chair, we only have so much time. We don't need to go over the past justices' credentials. I've already
that was the premise of the question. But let me let me definitely recognize that the point that the minister has made, and indeed that the Chief Justice made when we met with him, that judges throughout Canada, whether they're on the Superior Courts or on the Court of Appeal or on the Supreme Court of Canada, are in fact dealing with roughly half of their docket in the criminal law field. The other 8 justices now currently on the Supreme Court of Canada, as we've seen in their work over the past, even the past 12 months, are very deeply involved in the criminal law field, and we should, with confidence here in this committee and as Canadians, with this appointment, appreciate that the Supreme Court of Canada has a lot of strength in its current membership, and that Justice O'Bonsawin will add to that strength.
Thank you. But am I
Ms.
correct,
Finley,
Mr. Lin-
you only had 2 seconds left, so I apologize. Your time is up.
Thank you.
Thank you. I'll go over to Madame Diab for 5 minutes.
Merci beaucoup, Monsieur.
Thank you very much, Chair. First of all, welcome, Minister and Chairman of the Board. I want to thank you and all the members of the Independent Advisory Board for this, the work you've done for the nomination. It's historical today.
You spoke about the nomination process and the fact that, and that was your word, it's not, English isn't my first language, but I liked it, that it's an episodic appointment, and that at the moment we probably have some time till next time. You also spoke about the Honourable Kim Campbell, as well as others, talking about that it would be great to broaden the lawyers and judges so that they have more time to consider, but also to give them more information and to give, members of the public, as well as us parliamentarians and everybody, the role of a Supreme Court justice. I mean, you've touched on that today in your opening remarks, but also questions from everybody around the table in terms of what are the qualities, both professionally as well as personally, as well as ability to communicate in languages, etc., bilingualism. So I guess what I want to ask you is the importance as well of the process of encouraging and including and having inclusion of diverse candidates to even consider themselves applying to this position, because it is the highest court in the land. And, somewhat similar to even women or people of minorities or anybody applying to be members of parliament. These are very respected positions that many people don't see themselves in reflected. And I want to congratulate you today, because the more we can have a Supreme Court of Canada that reflects the population of Canadians, that's what we need to aim for. Can you tell us, for whatever moments we have remaining, Mr. McLaughlin, what do you anticipate we could do? Or what are your recommendations? And then if we have time, Minister, what can you do as the Minister? And what can we do to help you as parliamentarians?
Well, I would encourage, whether it's members of this committee or Canadians who are following this, if they haven't done so, to watch the interview. It's a feature interview with Justice Mehmet Jamal in late June that was on the CTV, and I expect it's easy to find on the internet. And beyond the formal steps that we identify, such as the Supreme Court of Canada sitting as it will in mid-September in Quebec City, to get out more. I think every one of us here today might, between now and the end of September, pick up the phone and call someone that might someday be thinking about this, or be ready to start thinking, and go for a walk on the beach or have a cup of coffee. Or that's exactly what is involved in building the kind of, or a walk in the snow, in the culture of encouragement that I spoke about. And I think it's very similar to the encouragement that many of you have gone through to become members of Parliament. You have to think a little bit ahead and what's involved and how you get the people around you prepared, and actually start looking at what's involved in filling out the application, which is no small piece of work.
In my outreach across a variety of different communities since 2019, one of the single most important factors that I have identified, or people have identified as a fact, is mentorship. Is people within society, within the profession, particularly senior people within the profession, say to somebody younger, you should be thinking about this. You should be thinking about applying to the bench. You should be thinking about applying, or if you're on the bench, mentors saying you should think about an elevation and applying, or you should be thinking about applying to the Supreme Court. And we all have a responsibility to do that in whatever walk of life we are in. We have put together, I think, a good process, this current process. We put together a different process with Quebec. We extended an offer to Quebec in the last round, and the government of Quebec accepted it, to have a much more interactive process that reflected the kinds of discussions that had been had over the past 20 years with Quebec. I'm proud of all of that. But I'm also open to making the processes themselves better. Whether it's more time, better timing, but also other
Thank
other
you
ideas.
to both of you. Thank you.
Thank you, Madam Diab. Next, I'm going to condense it to a 4-minute, Mr. Caputo for 4 minutes, and then we'll go to Mr. Maloney and close.
Thank you very much, Chair. And thank you as well to Mr. McLaughlin and Minister Lametti. It's good to see you all, and I hope that you've had a good and restful summer. I want to first take this time to thank Justice Moldaver for his service. He was, in my view, a pioneer on an area that I focused a lot on in my legal career, and that was with respect to bringing awareness in relation to sexual offenses against children and internet luring. He wrote some very critical decisions when on the Ontario Court of Appeal that still resonate today. I'm thinking of the Woodward decision, for instance. And thank you, Minister, as well. You mentioned Justice Marchand is a recent appointee to the British Columbia Court of Appeal. He's of Indigenous heritage, and I had the honor of appearing before him when he was a provincial court judge and a Supreme Court judge, and now he's on the Court of Appeal. So I recognize the work that has been done with these appointments, and obviously I want to selection. In Kamloops, Thompson, Caribou, where I reside and where I practiced law prior to becoming a parliamentarian, the decisions of the Supreme Court of Canada were significant, particularly as they did relate to criminal law, where I focused. And my question for both of you here today is this. We've had decisions like the Jordan decision, the Zora decision, and the Antic decision, and they really do have an impact on how courts operate, particularly in smaller centers. For instance, Clearwater is in my riding, and it may only sit one time every 2 months. What experience, in your view, does Justice O'Bonsawin bring that will assist with the administration of justice in smaller and rural communities?
Thank you for that question, Mr. Caputo. It's an important one, and I'm pleased that based on your experience, you asked that question. She comes from a small town in northern Ontario, and she comes from two minority communities, overlapping minority communities. And so I think she brings that experience with her when it comes to the administration of justice, when it comes to making sure that courts respect or are in a position to respect time delays, for example. You mentioned Jordan. And so there is that life experience that's going to be critically important to the way she handles those issues. And that in turn will help the rest of us as elected parliamentarians when we're thinking about resource questions or other, whether they be human or financial, or other issues to help do our part to make sure that we address those issues in the criminal justice, the administration of justice.
If I add to that point, Justice O'Bonsawin had administrative responsibility as the judge for the court in Lornignal, which is a small community to the southeast of Ottawa. She, in one of the cases that was included in her application, she refers to a decision that where she, on appeal, dealt with, in effect, a child situation where the Jordan principles had been applied, and she overruled it on appeal. And I note also that she, at various stages in her career, has assisted with the legal aid clinics, including to serve Indigenous persons.
Thank you, Mr. Caputo.
Thank you. I believe my time is already up here.
Appreciate it. Thank you, Mr. Caputo. And last, I want to welcome Mr. Maloney to this committee today. So, Mr. Maloney, for 4 minutes.
Thank you, Chair, and thank you, members, for allowing me to participate in this landmark occasion. It really is a significant day with this appointment, and I'm honored to be here. And I just want to add my thanks to the list of people who have mentioned Justice Moldaver, because he's a remarkable jurist, a great intellect, but he's also an exceptional individual. My first question is for Mr. McLaughlin. You mentioned these networks of encouragement. In my experience, the legal community has an eye on when these appointments or vacancies become open, but they know less about the committee, the board that you chair. Has there been any process or any thought given to broadening these networks of encouragement to getting people to participate in the board? Because I'll premise that by saying that the board has been different for each of the 5 appointments that have been made over the last number of years.
And in terms of how the board has evolved or changed for different appointments, I expect that may also reflect the jurisdictional or regional representation that is attached to the openings as they arise. This is my first opportunity, as you know, to be involved. Let me say, I was very impressed by not only the caliber and the experience and lively commitment of each of the board members, but how we came together, most of us not knowing each other, and actually had a very successful collaboration and a lot of fun getting to the result that we have today. But I take your point well, as the process of appointing Supreme Court judges and encouraging people to think about when an opening might arise, when they should be ready to become a candidate. This process is part of making that more visible and known and public, including in this appearance and discussion that we are having today and that will take place this afternoon. We're making headway. This is now 6 years since this started in Canada, and as one who's been involved this time for the first time, I've been very impressed in how people have responded, including the deliberations that we're having here today.
Thank you for that. I've got a minute left. A quick question. Minister Lametti, you mentioned that the importance at the beginning of, to use your words, giving Canadians confidence and trust in the process. That is critically important because, as you know, I've practiced before the courts in Ontario for over 20 years before going into politics, and I continue to be of the view that we have one of the greatest judicial systems in the world, and anything that is done or said that insinuates that we don't, I take great offense to. So there's been some questions even today nibbling around the edges about some of the process involved. Have any of the steps taken or any of the processes implemented in any way, shape, or form jeopardized that reputation or the integrity of our courts?
Thanks for that question. I share your belief that we have the best court system in the world. I really believe that. It can be improved, but I believe we're starting from a pretty good place. No, there was nothing in the process that I believe taints in any way the reputation of our courts. It's a non-partisan process. It's transparent. There were very high-quality people who applied and who were evaluated through the system, and the evaluators were outstanding, and I am pleased with this process that we're currently undergoing as well.
As am I. Thank you very much.
Thank you, Mr. Maloney. I want to thank all my colleagues. I want to thank Mr. Lametti, Mr. McLaughlin for all being here in this historical meeting, and we will now, sorry, Mr. Anand-Singari. Point of order.
Mr. Chair, I'd like to take a moment just to thank our clerk, who I understand will be leaving us as of September. So I want to thank him for his incredible service to this committee.
Thank you. We once again get to thank Jean-Francois. Thank you, clerk. And that concludes this meeting, and we'll see many of you shortly at 2 o'clock. Thank you.